Joe, we couldn't hear you.
Try now.
Robert Nelson Jr.
All right, this is the case of the people of the state of Michigan versus Robert Donald Nelson Jr., case number 25-3605FY. Mr. Nelson, you gave some contact information with a Bitely mailing address. Is that correct?
That's the only mailing address that I've had recently.
All right. Can you still get mail at that address?
Actually, I am not sure. I cannot. So I can get mail
Okay.
at another address that I'll update with you guys later if you'd like.
Yes, we will need that. Is phone ending in 4094 still a good phone number for you?
No, sir.
All right. Do you have another phone number?
Yes, sir. Yes.
What is that?
231-250-4656.
And you don't know your email address, is that correct?
I do know one. Yes.
Will you receive, if we send an email, will you receive it?
No, because I'm currently incarcerated, sir.
No, I understand that, but if you were out, would you receive it?
Yes.
All right, what is that email address?
It'd be twisted, TWIZTED, Ginge, GING 1992 @gmail.com.
All right. Did you have the opportunity to meet with somebody from the public defender's office?
Yes, sir.
I have a complaint that alleges that on or about July 1st, 2025, in the city of Cadillac of Wexford County, it is alleged in count number 1 that you committed the offense of possession of controlled substance analog, in particular amphetamine. That is a felony punishable by up to 2 years in prison and or a fine of $2,000. The prosecution has opted to charge you as a second or subsequent offender, meaning that you have at least one prior drug conviction in your past. That makes that 2-year felony a 4-year felony and the $2,000 a $4,000 fine. And the alternative, they have also charged you with a habitual fourth offender notice, meaning that you have at least 3 prior either completed or attempted felonies in your past. That makes that 2-year felony punishable by up to 15 years in prison. Do you understand those charges and the potential penalties?
No, Your Honor.
Do you understand that with the information that they have elected to charge you as possession of an analog, which is a 2-year felony? Do you understand that?
Possession of an analog.
Yeah,
amphetamine. But July 1st, I didn't. Okay. I wasn't charged with possession.
Okay, hold on. All right,
sir.
I'm not asking you if you agree with the charges. I'm asking you, do you understand that based on the information the prosecution has, this is what you have been charged with?
Yes, Your Honor.
All right. Do you understand that that on its own is a 2-year felony? The second subsequent makes it a 4-year felony. And then if they move forward on the habitual offender fourth, that makes it a 15-year felony. Do you understand that?
Yes.
Now, they can only go forward on one of the enhancements, not both. So if this case were to go to trial, they would have to choose one of those enhancements over the other. Do you understand that? Yes?
Yes.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to have an attorney present at all phases throughout this process. And if you could not afford one, one would be appointed to represent you, but you may be required to repay a portion of that expense. Do you understand that? Yes.
Sir. Yes.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I'd like to request an attorney.
All right, the court will make a referral to the public defender's office for the appointment of an attorney. Enter a not guilty plea on your behalf, and we'll set the matter for a preliminary examination. That's a hearing that happens here in the district court within 21 days. At that hearing, the prosecution will be required to prove two things. One, probable cause that this crime had occurred, and two, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show in 10 as a juvenile receiving and concealing a motor vehicle. In 11, failed to appear for a traffic violation. In 11, failed to appear for a traffic violation. In 12, operating with the presence of a controlled substance, possession of marijuana. In 13, a delivery manufacturing of a controlled substance. In 13, delivery manufacture of ecstasy or MDMA. In 16, a driving license suspended and an assault and battery. In 23, a domestic violence and attempted resist and obstruct. In 23, two jostlings and a domestic. And in 24, a possession of methamphetamine. I show that there is currently a bench warrant for a fail to appear out of White Cloud. Two bench warrants from the same day. There's a child support warrant. He's currently on probation out of the 28th Circuit Court until I think 27, if I recall correctly, for the possession of meth. And it looks like, based on my reading of lien and the probable cause affidavit, he has 5 failed to appears in his past. The praxis scores him at a risk level 8. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. I realize it's largely academic with some of those holds out there right now. I'm not sure what will or won't happen with probation. To my knowledge, probation hasn't themselves placed a probation violation hold. If I'm mistaken, I'm sure the court of the people will correct me on that. I would ask the court to set preferably as low of a bond as possible. We do want to see him getting credit for time served with probation, not parole. He's not sitting on any dead time, even if there were a hold. So, and again, I'm not sure that there is. He is low income, so even a low bond is going to be very difficult for him to reach. But as he did note, he does have an address in the local area. He is going to get to the court, and I presume the public defender's office as well. That way we can stay in touch with him. I do believe my office is familiar with him from past representations. I don't believe I was the attorney of record, but we do have multiple attorneys in my office, obviously. We do have our office investigator, our office social worker, Mr. Henniger, I believe is in the courtroom presently, and he always helps people who need help with housing, transportation, other aspects. And I think I saw him raising his hand that he might need some of that. So I'll definitely make sure that Mr. Henniger is aware of that. And I would encourage all of our clients to use his services, to be frank. Knowing all of that, Your Honor, I would ask the court to, again, keep the bond as low as possible. He may or may not have a statement to make. I may have misinterpreted the raising of his hand. Thank you.
Thank you. Ms. Lawrence, any comment regarding bond?
Thank you, Your Honor. I think it's clear from the defendant's record as well as his current bench warrants, he is completely and utterly a flight risk. I don't think he is a good candidate for PR. Given the habitual force, this also makes this a pretty serious level felony. Given that, I would ask for a monetary bond in the amount of $50,000 cash surety. And given the charges, I would also request the court to impose random drug testing as well. Thank you.
Thank you. Mr. Nelson, did you have a comment about bond at all? I don't want you to say anything about the case, but.
I would like to know if I might be able to get a bond to rehabilitation.
Okay.
I would like to complete my programming.
Have you gone to rehab before?
One time, Your Honor.
How long ago was that?
Time. I was just there a couple months ago. And I did not complete. my
This is
program.
alleged to have happened in July. Was it after July that you went to rehab?
Yes, Your Honor. Yes, Your Honor.
And was that inpatient or outpatient?
Residential, yeah.
Residential? Was that part of your requirement for probation?
Yes, Your Honor.
All right, the court does believe a monetary bond is appropriate given the fail to appears that the defendant has. I do find him as a flight risk. Mr. Nelson, as a condition of your bond, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any illegal controlled substances, including recreational marijuana, and you'll be subject to random testing for that. I'm not going to order a release for treatment now because there's another hurdle that you're likely gonna get through, which is a probation violation. However, I will state that if that hurdle gets taken care of, I'm not opposed to a motion to brought back before me for release to treatment.
Thank you, Your Honor.
Bond will be set at $25,000 cash surety. Corrections, can we have Mr. Schmidt back, please? Yes, sir. Counsel, can you approach? Person at the Wexford County Jail, please state your name for the record.
Christy Terry.
This is case number 26-215-SM, the people of the state of Michigan versus Christy Lynn Terry. Ma'am, you met with somebody from Community Corrections today and gave them some contact information. Was that information accurate?
Yes,
Did you have the opportunity to meet with somebody from the defender's office today? Did you meet with Mr. Hartel perhaps?
Oh, yeah.
From the defender's
Yes.
office? I have a complaint that alleges that on or about January 20th, 2026 in the city of Cadillac of Wexford County, it's alleged in count number 1 that you committed the offense of domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Do you understand those charges and the potential penalties?
yes,
Did you read and sign an advice of rights form there at the jail? It talked about your rights to an attorney and your rights to a trial.
yes,
Do you understand those rights?
yes,
You have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one would be appointed to represent you at public expense. But you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
court appointed attorney.
All right, court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf. And we'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there is a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show in 09 the use of a controlled substance, 11 a domestic violence, 13 false report of a misdemeanor, 13 retail fraud third, 14 attempted retail fraud second, 16 attempted retail fraud second, 17 an attempt to resist and obstruct. In 17 a retail fraud second, 18 possession of narcotic less than 25 grams, 17 possession of analog, 23 possession of meth second, 23 assault and battery on the local record, but not her CCH. And 13, there's an operating without a license on person. And in 16, a retail fraud third. The praxis scores her at a risk level 1. However, I believe that's inaccurate. She self-reported that she has no criminal history. We know that's wrong, so she should receive a point there. History of violent convictions. There was a report of a no. I show a domestic and an assault in her past. So I believe she does have the 2 or more violent convictions that would add a point. History of drug abuse, reported no. However, given the drug convictions in her past, I believe that is inaccurate. So I believe another point is added there, which by my count brings her to a risk level 4. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. I would ask the court to consider a personal recognizance bond in this matter. Despite some of the noted concerns, it is still a misdemeanor allegation. I won't go into anything protected by attorney-client privilege. When I spoke with her earlier, for obvious reasons, I may or may not be the attorney permanently assigned to her case. She is aware of that. She has informed me that she does have lifelong ties to the Cadillac area. I don't know if the court's going to have a no contact order. I told her often it does. And I'm not sure if the other party lives at the address she gave me, so I don't know if she'll be able to return to that or not, but she does have strong ties. She informed me she can find alternative housing if needed. However, I did tell her, as I tell everyone, if she needs any help, our office social worker, Mr. Henniger, who I believe is still in the courtroom presently, will gladly help her with any of the things she might need, housing, transportation, things of that nature. I would ask the court to consider non-monetary bond conditions, perhaps that no contact order, things of that nature, but she is unfortunately between jobs, does not have substantial savings. Even a small bond would be impossible for her. I ask the court to factor that in. Thank you.
Thank you. Ms. Lawrence?
Thank you, Your Honor. Given the nature of the charge, I would ask the court to impose a no contact order with the victim. I will note it is alleged in here that the defendant had been drinking during this incident. So I would also ask for random alcohol testing. Given her criminal history, I do think a monetary bond would be appropriate in this case, but I will leave that to the discretion of the court.
Thank you. Defendant's most recent assaultive conviction is back from 23. So I do find that she is a threat. Ms. Terry, as a condition of your bond, you are to appear as ordered, keep your contact information current, not leave the state without permission, and commit no new crimes. Because alcohol is alleged to have been involved here, I'm going to order that you not consume alcohol. You'll be subject to random testing. Also, because of your drug past, I'm going to order that you not consume any illegal controlled substances, including recreational marijuana, and subject to random testing for that. There is a no contact order with J Spore. No contact means no contact. You cannot have any contact of any kind, not by phone, text, email, social media, or anybody acting on your behalf. I'm also ordering that you not purchase or possess any firearms or weapons, and that you not act in any threatening, intimidating, or harassing behavior. Bond will be set at a $2,500 10% bond. Ma'am, just a reminder that any violation of your bond conditions could result in you being arrested without a warrant, brought back to jail, and have your bond revoked. If you are able to post bond, you'll need to come over to the courthouse immediately to get signed up for your testing at Community Corrections. Do you understand that?
Okay,
Do you understand that?
yeah.
All right. All right. Thank you, jail.
Thank you.